everybody. So wonderful to see so many familiar faces and to have the chance to celebrate Debbie today and to kick off a conference, which hopefully many of you will stick around for tomorrow. The plan for this evening is to have a chance to hear from the wonderful co-founders of the clinic, Debbie, John, and Nancy, in a conversation that former immigration judge Jeff Chase will be facilitating. So thank you all so much for joining us for this wonderful celebration. And I'll hand it over to you.
Thank you, Sabi. Am I picking up on the mic? You hear? So, as you know, we're here to celebrate the remarkable career of Deborah Anker and the remarkable work of the clinic founded by Debbie, John, and Nancy nearly 40 years ago. I think next year will be 40 years. So to set the stage, okay, for the creation of the clinic, Debbie, there were a couple of big legal developments in 1968 and 1980 that preceded the creation of the clinic. So do you want to sort of summarize?
Sure. In 1968, the U.S. became a signatory to the International Refugee Convention, actually technically to the protocol, and that was a major move, considering our refugee policy was completely dominated by foreign policy before that, and this was a commitment to an international humanitarian definition and regime. But nothing happened, of course. And in fact, we had the definition of refugee in the convention and the protocol is someone with a well-founded fear of persecution for reasons of race, religion, nationality, membership in a particular social group, or political opinion. Our law on the books at that point defined a refugee as somebody fleeing a communist or communist-dominated country. So it was completely inconsistent with our international, it was completely inconsistent. And then in 1980, we finally shaped up, and we passed enacted the Refugee Act of 1980, and at least formally, our law was, similar to, was very close to the definition in the Refugee Convention and in international law. That, of course, didn't change the practice either.
And I just want to,
the article,
pretty much simultaneous with the enactment of the 80 Act, you and Mike Posner had authored this remarkable article that was so remarkable that it was cited by the Supreme Court in Cardozo Fonseca. So what was your goal in writing that
So we
article?
wrote an article, and we wanted to really emphasize that the switch to an international definition of refugee was incredibly significant and meant a whole new or reorientation of our refugee policy. And we really wanted the courts and others to understand that international law was the foundation of our refugee law, and certainly not discrimination, certainly not ideological discrimination. And actually, there was the first case under the Refugee Act of 1980, Cardozo Fonseca, and was argued before the court, and the court specific issue in that case was whether there was a lower standard of proof to prove that you're a refugee, lower than a probability standard. And it did, and the court, actually citing our article, said if one thing is clear from the Refugee Act of 1980, legislative records of the Refugee Act of 1980, it is that Congress wanted us to conform to our international obligations under the Refugee Convention, and in adjudicating claims follow the definition of refugee in the convention, which is somebody with did I say this already, well-founded fear of persecution for reasons of race, religion, etc. So that was just a major turning point, and we had sort of just.
Well, we had this sea change in in 1980 with the enactment of this act, as you explained, and then your article. And then, John, when you were actually bringing these cases before the immigration judges and INS, did you see a corresponding sea change in the way they were deciding the cases in the early 80s?
No, not at that point. Not at that point.
And Nancy, you actually had an anecdote that really brought that point home.
Sure. Yeah, Dan, I'm sure you were there, okay? But when the American Baptist Church suit was settled, that was in 1991, right? And that was a lawsuit that had challenged the way that the government had been dealing with the Central American cases. And basically what they showed in that suit was that Salvadorans were being granted at a rate of about 1%, and Guatemalans in about 3%. And, this is in the middle of a genocide in Guatemala and a horrible war where people were being, rounded up and disappeared.
Backed by
in
the
Salvador.
U.S. Backed by the U.S.
Yeah, backed by the U.S. Let's remember that.
That's where they got their guns from.
But, and 80%, more than 80% in Canada. But in any case, we held a press conference when this lawsuit was settled because this was requiring them to re-adjudicate all the cases that they had denied for all the people who were still in the U.S. And so we had this press conference, and I remember sitting around after the, and talking about how wonderful this was and how horrible people were being treated and how great this was, and sitting with a reporter. There was a small group of us. And it was a small group at the time because it was a small group of like guild lawyers and AILA lawyers and, people who did asylum was a relatively small group and everybody was there and everyone knew each other. And the reporter said, how hard can it really be? This was like after the thing was over. And we were sitting around and we knew every asylum case that had ever been granted in the Boston court. I remember sitting there and they were going, it was like, okay, you had that Guatemalan, and you had the Sri Lankan, and we added them all up, and there were less than 10 cases, actually.
In 10 years.
In 10 years, yeah.
So that was the landscape into which the clinic was created in 1984. And Debbie, what was, I guess, the philosophy to bring about change, as you've said many times, from the bottom up?
Yeah, so our approach was we couldn't exactly go into federal court right away, although Ira did. But wait, what was the question again?
That faced with this reality, what was your philosophy about bringing on about change?
So we just, since we needed to find sources of law, and we found them in international sources, and we also found them in our actual cases. So we kept bringing cases before the immigration court, and where we won them, we would share them, and sort of that was sort of the meat of our work was we were just trying to do cases at a lower level, and if you change the cases at the lower level, you change the underlying institutions, you gradually will change the area of law because you couldn't start top down. Eventually, we and a lot of people in this room did a lot of litigation, but that was our idea, and we did change. And this is the thing. On the one hand, this is international law. On the other hand, the conditions in the immigration agencies were unbelievable. We weren't even under the Administrative Procedure Act. This was the lowest level administrative agency that you could possibly imagine. And yeah, so it was.
And when you say you shared things, can you maybe all three
so
of you?
as we began to do cases, we shared those cases. The Board of Immigration Appeals, which was the administrative appellate body, issued very few decisions, but they issued some of the best decisions were unpublished. And so we would just circulate these unpublished decisions, say, use these, let them say that it's not binding. And
then IJ decisions, I believe.
And IJ decisions, and this was a period, I feel like I was so blessed, because just at the time when I was getting into this, it was also a moment internationally where there was people, scholars and advocates in different countries that were parties to the Refugee Convention who were basically trying to do the same thing, argue that that the convention was a different definition of refugee. it required a law-like approach, and I'm sort of.
Could I just jump in also?
Sure.
So it also meant, I think, really going in there and figuring out what was really going on with people's lives and why were they really fleeing, and sort of digging at it and figuring out their stories and documenting the country conditions and looking at international instruments, et cetera, to make the argument. So piece by piece by piece, we started building these cases.
And
Yeah.
we started getting cases from other jurisdictions. We got cases from Canada. We got cases from, and we had gender cases from different. When we eventually got into gender work, we started publicizing these decisions and publishing them. We have a book on gender asylum decisions in different countries. So we just went to all sorts of different sources that seemed very legitimate, because this was international law. And I should say Robert Barsky's here, who has written about the U.S. accession to the '67 Convention and what got us to do that, which is a really interesting piece of civil rights history in the U.S. and other things. But I began to get to know these people. What an incredible privilege. I worked closely with Jim Hathaway, who's just far and above the, I don't know what, the dean of international refugee law. Yeah. So it was fun. It was interesting. It was like we're in this right? We're in this horrible hole of an area of law and of a bureaucracy, and we just said, okay, the sky's the limit. This is what you're going to throw at us. We're going to throw at you an administrative decision or a high court decision from the UK or something. There was a as we got into the gender work, there was I'm going on much too long. Yeah.
But I mean, people should also
It's your
remember
time.
this was way before the internet. This was way before we would have email chains where we share. This was like gold. What you were putting out and sharing with the rest
we had a
of us.
wonderful decision from the House of Lords in the UK, Shah versus Islam, and on gender asylum. I know Nancy will talk a little bit more about our getting to gender asylum, but.
And there was your book, The Law of Asylum.
And I right. And I I wrote this book on the Law of Asylum. And I remember I was when I was at the law school here, and I for some senior paper or something, I wrote I wrote up Law of Asylum in the United States, and it was 34 pages, and I had every single case that was decided on asylum law. I was like, gave me such a sense of control over the world, I could actually, but now there's a little bit more than that, and the law is more complex, and it's harder to deal with, and as complexity produces that.
And I think there's a large number of students who've worked with you on
Oh,
your
yeah,
book,
no,
right?
with the book, every year the students have worked with me. I couldn't have done it without them. There's a bunch of people here who've helped me with it.
Young
A
Ho is
great
one of
deal.
them.
Young Ho, yeah. Hi.
So
Yeah.
these were these remarkable resources that all the rest of us, were relying on, that we really couldn't have practiced and won cases without. And then as John mentioned a little while ago, the types of cases that you were doing also were shaping, where your work was going, right?
Right.
So I know one of the things when we've spoken, previously, you said there started to emerge cases of Iranian women asylum cases.
Yeah, there were a number of, I was thinking as we prepared ourselves, we were thinking about all the different cases we did during that time, and that started, and Iranian women was one of those groups of women that I ended up meeting representing in the late 80s, early 90s, who had come out of the Iranian Revolution, and there were a number of Marxist women who were very, ideologically very strong women who had been targeted on account of their political opinion because they wouldn't go along with the revolution, and the men went after them. And so those were just some of the stories, and that's sort of the beginning of a lot of the work that we did around women. But there were a lot of other people from Africa, from Zaire, from South Africa. You did a lot of Eritrean cases, right? We did Ethiopian cases.
Nancy,
right?
You started to see.
Yeah.
Haitian work. We did a lot of Haitian work.
And you did detention work too. So you also represented a lot of
The
folks.
Sri Lankans. There were a lot of
Lankans,
Sri
right.
Lankans who were just trying to get to Canada, but they would get pulled off the plane in Boston and detained for 2 years. Yeah.
And when we talked about the cases of Iranian women, that kind of led to the clinic's first ever amicus brief in a case called Fatin v. INS in the Third Circuit. And Debbie, do you want to discuss that briefly, including who the judge was that wrote the decision?
Yeah, Fatin involved a Iranian woman and who was applying for asylum on the basis of political opinion and the particular social group ground. Now, the particular social group ground, the Board of Immigration Appeals had said was sort of catch-all ground. If you had a characteristic that was fundamental and you shouldn't have to change, then it qualified as a particular social group. So we started arguing, of course, women, gender is such, in fact, the Board of Immigration Appeals in that decision, matter of Acosta, named sex as one of the grounds. So this became our theme as and the interpretation that we really pushed forward at that time. So Fatin was an Iranian woman, and we wrote an amicus brief. It was not a well litigated case. It was not a well briefed case. We put in our amicus brief, and it was Judge Alito who later, of course, joined the Supreme Court to do. He did good things here. So this case, he in dicta, because he said, gender should define a particular social group, and feminism is a political opinion. Of course, she didn't show that she had strong enough feminist beliefs that she would let herself be physically harmed or killed, so she doesn't qualify as having such a feminist political opinion. But we had those two. Those were very advanced ideas, and I think there's a way in which he saw right on the surface of it. Of course, gender qualifies. But I'll stop there.
All right, and then finally in 1990, 10 years after the 1980 Act was passed, INS got around to creating regulations, implementing it, and then very shortly after, I think it was in early 91, they created these asylum offices that were supposed to be an improvement and actually apply the law, the way it was supposed to be. So Nancy and John, did you see a major change on the ground when the asylum offices opened?
Yes.
Well, we did. We definitely did, yes. And we had a great hope, I'll be honest with you, because this one time, we'd been dealing with the adjudications officers who never understood the claims. They thought it was all about coming from, and oftentimes, coming from Eastern Europe, escaping communism, and the judges who weren't granting cases. And so the possibility of this corps of officers who were trained as human rights officers really was something that we looked up to, we really hoped for, right?
So, this is another thing. We enacted the Refugee Act of 1980 in 1980. 10 years later it took before they had created any adjudicative system for it. It's
10 years and 10 cases.
10 years and 10 cases, exactly.
And then when they did create it, Boston was just a circuit ride for an asylum office that was in Newark, and I was told they weren't really getting up here that often. So Nancy kind of explained how the clinic helped move that along.
Okay, so they weren't getting here, and they weren't being given an office, and they had no place to sit. And when they finally did say, well, you can use that cubicle over there, and your chair would be outside the cubicle, and it was horrible, right? And it really, what it felt like was going on was that the officers in the local office really felt dissed because this had been their job and now it was being given to these kind of special people who were coming in with all this training. So in any case, they sporadically could find a place to sit and often not. And so we were going down to New Jersey to try to get cases that we really needed heard. And there's another story about the asylum bus, but somebody got a big van one day. This wasn't us, it was one of our colleagues. Got a big van and brought several of her clients down. Anyway, what we finally did is we talked to a community organization. We said, if we find you an office, will you come? And they said yes. And so we got a community organization over in Roxbury to make an office available to them. and it was an office in a building that had a daycare center. And so the Asylum Office, they had this little office in the corner, and there were chairs in the hallway, and there were all these little children running around. And they came.
So this was a little-known way that the clinic helped facilitate asylum hearings in the Boston.
I think that what happened at that point is you start with real hope, and then you have to deal with reality, which is not happening, right?
Yeah, right.
So
Don't
in
get
this
us going
particular
on
case,
today.
we're dealing with Haitians. We'll talk about that more later. But suddenly we had a lot of Haitian clients, and so we needed to get it done, and that's where we jumped in. So I think the Haitian clients felt much better going to, was it Roxbury or Dorchester?
I think it was Roxbury.
Roxbury. I think they felt much better going there, so that was good.
So that leads us into the next topic, which is the important role that Haitian cases then played in the development of the clinic. And I know, Debbie, I believe you served as an expert on asylum law. I'll let you explain. I'll let you explain.
Yeah, well, I went down to, I don't know what started it exactly, but I started going down to Miami to work with Ira on, he was doing this Ira Kurzban, one of the great leaders of our field. But we went down to, I went down to Florida, and he was involved in a number of class action suits, one of which went to the court. Nothing but did anything but John V. Nelson go to the Supreme Court? Oh, they did, that's right. Yeah. But, yes, and in one of them I testified, right, Judge Spellman, wasn't it? And, yeah.
So that was one way they were working regarding Haitian cases. And then Nancy had an extraordinary
Ira,
story.
by the way, to say one thing, Ira also claims that I brought Haagen-Dazs ice cream to the Fifth Circuit appeal, and has always appreciated that I did that. Anyway, go ahead. What? That's why we won. Yeah.
It's the little details, right?
Yeah.
So,
okay, go ahead, Nancy.
Nancy, we wanted to talk about the work that you actually did in country in Haiti.
Sure. Yeah, so in the early 90s, when we were really focusing on gender issues and trying to get, gender recognized as a basis for asylum, and in trying to circulate cases and trying to really, think things through and find a way to present these cases, one of the issues was that everything involving sexual abuse and rape was personalized, right? And you often had a hard time even getting a judge to listen to it, but then if it was heard, it was sort of dismissed as some sort of a personal matter and totally depoliticized. And so we were at the time dealing with a lot of Haitian cases and seeing a lot of women coming in who had these horrific tales of rape. And this was at the time when Aristide, who had been the first democratically elected president of Haiti, had been deposed, and anybody who had supported him or anybody who had, it was a very grassroots movement. So, teaching somebody to read or cleaning the streets meant you were, a political opponent of the coup and should be killed. Or, in any case, we were hearing a lot of these stories, and we were representing women. And what we wanted to try to, like Debbie is talking about using international law and how do you meld the two and sort of move things forward. So one of the things we worked on, and we did this with a group of organizations. We did it with Madre in New York and the CUNY Women's International Human Rights Clinic, Center for Constitutional Rights. We all got together and we started collecting the stories, and the stories of our clients, of other people's clients. We talked to therapists who've been working with women, and then we went down to Haiti, and we worked with two women's organizations in Haiti, and collected stories from there, and we brought them back, and we presented them to the InterAmerican Human Rights Commission. And our goal was, obviously to get them to look at what was going on in Haiti, but it was also to try to get a finding that rape was torture. And we thought if we got a finding that rape was torture, we could take that and bring that back to our asylum cases, because if it's torture, it's got to be persecution, right? So that's what we did. And so when I went down, the first time I went, I met with this group of women, and I did, tried to explain what it was we were trying to do, and tried to be, I remember just trying to be as clear as I possibly could that I didn't lead these women to think that something was going to come, something tangible was going to come to them from this case, that it wasn't going to result in them getting reparations, it wasn't going to result in them getting asylum. What it was going to result in was a recognition of what had happened to them and to other women, and a way to move maybe things forward for other women. And so I did my spiel, and I said, tomorrow I'll be at this place at a certain time. If anybody would like to come and talk to me, that would be great. So the morning comes, I figure I'll see 2 or 3 people. They all showed up, right? And it's about 20 women, they all showed up. And then I said, we'll talk to you separately. We'll take each one of you, we'll go sit, we'll be, And they said, no, we want to tell it publicly. We want to tell our stories. And one by one, they stood up and they told their stories. It was so incredible. Anyway.
And I think these resulted in affidavits.
They resulted in affidavits, and we got them all together, and we did a hearing before the Inter-American Human Rights Commission, and we ultimately, we also asked them to go down and do a mission to Haiti, which they ended up doing, and we got a finding out of them that rape was torture, and that rape in the context that it was being inflicted on women in Haiti was also a crime against humanity. So.
And John, you talked about some of the students being involved in preparing the paperwork for filing, and
right.
how.
Right. Yes. I mean, there was a large number of students from the clinic who were very much involved. And one of the things that I had mentioned was that it really struck me that the night before we were going down to Washington with the documentation, a lot of people were working on these, a lot of women were working on these affidavits, and everybody was in tears because it was just so overwhelming.
And I mean,
It's
this
an
was
amazing
an
really
incredible
amazing.
accomplishment,
Yeah.
and incredible thinking outside of
Yeah.
the normal
Right.
way of how you how you change.
And something we did in conjunction with this also was, there was a unpublished Board of Immigration Appeals decision, matter of DV, and it found that it was a Haitian woman who was raped, actually raped in her home, and the board said this is a form of grievous harm. Almost, I remember getting young Ho to research this for me, and I said, it's a form of grievous harm amounting to persecution. He said, it said grievous harm, but it didn't say persecution. So anyway, thank you for that, but so that it was actually, I forget the person's name now, but there was a clinician, a clinical teacher in another law school who had represented her, and then led a petition, and we joined in a petition to get that case published. And I always feel badly because that really was the first gender asylum case, and it's just been ignored. And like many of the things that happened to the Haitian people have been ignored. But it was and that was the kind of thing that we did, right? We would have these unpublished board decisions, we'd petition to them. But you had to mobilize a lot of work. It was a lot of work. You didn't do it if you were going to fall flat on your face, These fights we went into to win, right?
Yeah. Can I just,
Yeah.
I'm talking about work.
Yeah,
I just
that's
want to
it.
add to this. Talk about cases. So we took on a lot of cases of people who'd come out of Guantanamo, who'd been released in the United States. And Ira, and I think was very much part of the work that you guys were doing. And one of the things that came out of it is that we came up with these documentation packets that would be useful around the country in actually presenting these cases. And I think that was really a very important piece. The students played a huge role in that as well. The community, the Haitian community, was very much involved. the struggle around Lavalas at the time was huge. We would meet on Fridays and Saturdays after work. They were so into it, and there were all these taxi cab drivers would show up. And ultimately, what happens? The Asylum Office really on this one they did the right thing. Almost, I think everybody that we represented ultimately got asylum. And a lot of them now have kids who are like teachers. There are a lot of people who are running they're pharmacists, a huge number of pharmacists. There are people who really move forward. It was an amazing experience, and it really touched the work we did. Yeah.
Yeah, that was a real example of change from the bottom up,
Bottom up.
as Debbie was talking about. Now, around the same time as the Haitian, the Inter-American Commission on Human Rights hearing, there were quite a few other things going on with the clinic. First of all, INS published gender guidelines at pretty much about the same time in the mid-90s. So Debbie, do you want to talk about what the clinic's role was?
Well, Canada had issued the first set of gender asylum guidelines, obviously at a very high level, explaining to people how women could qualify for asylum. And we started working with the Canadians. I don't know if it was on the Inter-American Commission or how it is that we first met up with the Canadians, but I'm in love with Canadians, even dual nationals. No, sorry.
You know,
But,
Nancy's Canadian. Her
they-
family's Canadian too.
You're dual national?
No,
You're
she's
dual national?
she could be.
I think so. I looked it up the
Those of
morning
you who have
after the
Canadian
election.
connections should
when-
really be exploring them now. So, Canada just did something terrible with the U.S. and this Safe
Yeah.
Third Country agreement. But if we have time to talk about it, I'll talk about that. But what was the
The
Guidelines.
INS
the
gender guidelines.
INS gender asylum guidelines. So we had been working also with a lot of reporters. There were women reporters who got the stories of our clients, our women clients, on the front page of the Times. I remember there was one woman who covered it on several different occasions, so we drafted guidelines for the INS to adopt that reference more of INS, of American law, et cetera, et cetera. We drafted them and we handed them over to INS, and we said we'd like you to adopt these as our guidelines, and they said yes. And I don't know how many people will really appreciate this, but I remember what I didn't want them to do. There was this, there's these horrible anti-immigrant groups now all over the place. But then it was the Federation for American Immigration Reform, and normally in a story like this, they would go to the other side, right? And they would go to FAIR. And every time I spoke to them, I said, whatever you do, don't talk to the people at FAIR. They're not legal experts. They're just a bunch of, right-wing political people who have a political agenda. If you want to say that about them, that's fine. But don't try to contradict an interpretation of the law that I'm telling you on the basis of something that they say. And I remember we handed it over to Phyllis Coven. It was a Memorial Day weekend. They published it. INS published it then because they thought, well, it won't get as much publicity, and we can get this out of the radar. And it was published. No reporters went to talk to FAIR. I actually, I was so pleased about that. I was just tickled pink.
And I think it was pretty much published the way you gave it to them, right?
And it published the way we stated it. Now, of course, we wanted it to go to regulations. Janet Reno, who vacated this horrible domestic violence asylum decision, matter of RA, which is a whole other story. But she vacated it, and to be redecided, the RA decision to be redecided in light of regulations which would be promulgated. And those regulations were never promulgated, and now the fewer regulations they promulgate, the better, I think, considering the way things have been going. But anyway.
And I believe the clinic's role in getting those gender guidelines produced resulted in your being awarded AILA's highest honor, which is not an annual award, but an award they give sporadically when something warrants it. So that was also, I think, right around the same time. And then also, right around that same time, you took a group of students to an important women's conference in China, I believe. Do you want to talk about that a little bit?
Yeah, we, Judge Grassley said. Yes. So there were these, I think every 10-year conferences about women, international conferences, which were very important, and they produced a lot of the international treaties about women. The convention on, again, there were a couple of those conventions, and so we went with a group of students to China. There was a women's conference. It was Hillary Clinton was the main speaker. It was women's rights are human rights, was the motto of the convention. We went. We got provisions put into the program of action, the platform of action that defined gender. Gender could define a particular social work group, and women who were persecuted on the basis of their gender should get asylum. And principles of non-refoulement, and so we got a bunch of things involving women and refugees into the platform of action. So that was very satisfying. And Nancy and I are refraining from telling you some of the most funny stories about
That'll be at the reception.
different story. China was so anxious to please and had this was so proud that it had this international conference, and they built all these things that kept collapsing. Anyway, yeah, toilet seats, and anyway, it was very funny.
I think we're going down that road.
But yeah, so anyway,
We've got-
Many of these
yeah,
things.
that was a very. So that what was it? The InterAmerican decision.
There was
the
the guidelines, DV got published.
DV gets published.
And the InterAmerican decision were like right
Yeah,
within
these
like
are-
a month of each other.
Yeah, this
They
all happened.
came.
Some of it happened on my
Weeks of each
birthday, I
other.
know that. But
Yeah, the guidelines were on his birthday.
my birthday.
So many of these highlights we were talking about occurred during the Clinton administration, and then moving now into the 2000s and the second President Bush, the George W. Bush administration, things changed quite a bit. And John had this fascinating story of the clinic's involvement in something that involved a factory raid, it involved children's asylum applications, it involved indigenous asylum applications, all kind of wrapped together. And do you want to maybe explain that?
Sure. I'll try to explain a little bit. So on March 6, 2007, ICE launched a factory raid on a plant a textile plant in New Bedford, Massachusetts. And they ended up detaining 361 workers. It was part of this plan that they have at the time, Bush 2, I think, had a plan that at the moment that they were implementing where they wanted to deport 1 million people a year for 10 years. And it was called, what's it called?
Operation Endgame.
Operation Endgame. Okay, so what they did is they came in and they descended on this plant in New Bedford, over 500 armed guards, dogs, helicopters, etc., and just took over this plant. And we remember that at that moment it was like a bomb had gone off in town, and that these people had disappeared. And so the immigrant rights community, the immigrant community down there, organized to get people to come in to launch some sort of a defense for the folks who had been picked up. And working with MIRA, which is the statewide organization, a number of other people, and a the larger immigrant bar. I mean, Massachusetts, as everybody knows here, I think, who's from here, is a very strong bar. And so it ranges from legal services to clinics, to private individuals, to guild members, et cetera. So they organized it so that they brought us in. And so we quickly, and we had, the way we all function, I know a lot of people here is what happens when when there are these detentions, you go in and you try to interview the people as quickly as you can to see if they need representation, et cetera, where they are, and all this to be sure they know they're told of their rights, et cetera. So we started jumping in, but we didn't know where they were, but finally by the end of the night, I think we found out that they had been taken to Fort Devens, a decommissioned military base in northern.
Anne was there. and
Yeah, a
Jason
lot of
was
colleagues
there.
here were there, yeah. And so they taken them and they had taken them to this detention center. So we ended up going there that night because we didn't know what was going on. And we ended up realizing that, one, that there was a large number of women. Two, that it seems like there were a large number of Guatemalans and Hondurans. And in the process, we also realized that something was going on. They were going to move them out. And this is not something that they normally did around here. In fact, they didn't. And so we started immediately, a bunch of us started going in and interviewing people, and a couple of others of us started working with Deckard, which is a local law firm, Harvey Kaplan, a number of different people, the ACLU, Mass Law Reform, et cetera, to come up with, to launch some sort of a legal challenge to this in federal court. And so we were going forward on that, but before we could actually stop them, and we ended up realizing that we were going to move them to Texas because we saw these signs on the doors and all that. It was clear they were moving them to Texas. So we jumped in, but before we could actually, just as we went to court to try to stop them, they had already moved them out. So we lost that one. They moved over 200 people to Texas, to El Paso and to Port Isabel. So we ended up going from there. A group of us ended up working for the next maybe 2 or 3 months trying to get these people out of detention in Texas. We were able to get finally over 200 people out of Texas. About 200 people were released of the 361. We got about 150 out of Texas. There's a whole group of us, including lawyers from Texas who are guild lawyers, and a lot of people here. Actually, the private bar really, a lot of people in the private bar really were able to get people out through bond hearings and stuff. So in that process, we ended up taking on a number of the clients. And of the clients that we took on, a big percentage of them were indigenous folks who had come from Guatemala and specifically from the Department of Quiché. And when we took them on, we ended up realizing we really didn't know that much about them. We had touched some Guatemalan cases in the 80s, but it was basically people who were like students and professionals and people who had been at the university and been targeted at other times in other ways by the Civil War in Guatemala. But we didn't know these folks. So we realized, ground up, we had to figure out what was going on with them. We had to figure out who they were and how to present their cases. So we actually turned to one of the main organizations down there. It's called Organización Maya Quiché, which has been one of the organizations that pulled us in, and they were a group of indigenous activists from the Quiché area. Actually, they came from targeted families, and they had been forced out during the war because they had organized to represent their community, we find out. So we turned to them, and they started guiding us on how to think through these cases and all that. So we ended up going forward on these cases. There was also a number of Honduran cases for women, and the gender work that we had been done sort of helped inform that work in many ways. So we ended up moving forward with those cases. Again, we were involved with the clinic and legal services, so a lot of students were involved in this work, and they did amazing work. So one of the cases that came out of this I want to talk about quickly is a case called Ordonez Kino, which was decided ultimately in 2014, I believe. And it involved a man who was an indigenous man who at the age of 6 had lost his hearing in a bombing. The community had been attacked. The father, and this had happened many times, the parents pick up their kids and they run when the soldiers attack. And in one of these situations, they got hit by a bomb. And as a result of it, the kid lost his hearing. He's also really, really sick for a number of days. He almost died. So there's a long history around it. So this case, we ended up presenting it, and there was a number of other things, but just to make it simple, we ended up presenting it before a local judge, and he was a judge who would be respected on other types of cases. He was actually very good on Haitian cases. And so we presented before this judge, and ultimately he found that, okay.
Explain what kind of judge it was? It was a
immigration judge.
Yeah.
Yeah, an immigration judge, sorry. Yeah. And so ultimately what he did is he found that, well, you know, what happened is that the harm that came out of this was, what really happened is that these communities were like collateral damage in the war. In reality, it was a war against the communist guerrillas or against the guerrilla forces, and it just happens that this happened. Okay, so of course we had presented the case very differently, and so we ended up taking it up and went to so he denied the claim, and it went up to the board, and they affirmed the judge's order, and then we took it up to the First Circuit. And ultimately what happened is Judge Thompson ended up writing the decision on this case, and she ended up coming up with a decision that was really groundbreaking for us. All right, it was groundbreaking for this work. It was a paradigm-changing shift, to put it that way. And what she ended up doing was taking what we had done is we very carefully attempted in this work to document what had happened during the Civil War and how these communities were really being attacked because of who they were and their opposition to the Latinos, and so it's race. And so she took all that information and she reviewed it, and she ended up focusing on what the conclusions to a Truth Commission report that had been acknowledged by the UN, and it's called Memories of Silence. And she took the conclusions and she said, this is a war where it was about race. The Civil War was about race. These attacks were specifically about race. And the only way you can really understand the cruelty of the attacks is to understand that there has this racial component to it. So then she said, so it's clearly and this is one, and it's one central reason. Okay, and so the
causation
judge's
standard
decision.
in the refugee definition.
Pardon me.
I was just saying the one central reason is the causation standard in the
Causation
refugee
standard,
definition.
right? And so she ended up saying, and so she said, so the judge's decision that it was based on just basically because they happened to be there was not supported by substantial evidence. And then she went to the second part, which is also a very important part. And what she did is she went to analyze the harm that the child faced. He as a child faced, and she basically turned to a previous decision that the First Circuit had issued involving another case that we had done, Mejia Romero, in which we had argued that in fact this is a Honduran child, and that what needed to happen was to analyze the child. You need to look at the child for what the child is, and basically analyze it based on what we call the child-centered approach, which is an approach that comes out of sort of the international standard of law and based on a lot of different things. And so in that case, Judge Stahl wrote a dissent in that case, which was an amazing dissent. And we took that, and which he agreed with us, and he went and he actually took it even further. And we ended up filing a motion for a rehearing en banc, and a rehearing en banc based on his dissent. The panel itself ended up vacating its own decision and sending the case back down for the board and the court to analyze the case or to decide the case based on the child-centered approach. So she took that child-centered approach and applied it to this case. And she saw the kid for who he was, and she saw the harm that he faced as a child, and the level of harm that not only he faced for what happened to him, but also how his family and community, the harm that his family and community faced, and put it all together and found that it was very evident that the totality of evidence showed that in fact he had suffered past persecution, and that the judge and the board's decision was not supported by substantial evidence, and so she sent the case back down to be decided that way. And ultimately, that case ended up being a groundbreaking case for us, a paradigm-changing case, because after that, suddenly these cases were understood. It was like the narrative totally changed in court about what these cases were about, and what you had to prove and what you didn't have to prove, and whether this harm was real or wasn't. Are they refugees or are they not? It changed it. And actually, you were saying, right, that after this, you want to explain?
Well, basically, just going into court after this to a judge, before a judge who didn't want to hear these cases before, and her basically referencing this case and saying, oh, is this like this case? And we said, yes. And she said, okay, I think we can settle this, right? Anyway, but the point is it was a whole different world.
And that's amazing. We're running a little short on time, so there were two more things I want to touch on quickly. One of them is extremely important, the domestic violence-based asylum cases. And there was another case during the Obama administration that had that similar effect, which was ARCG, which there was a particular social group created, and it wasn't the particular social group that the clinic had always advocated for, right? It was a narrower group that ARCG created. So I mean, what had the clinic always
Well, our position had been what Matter of Acosta had said, that sex itself, gender itself, could define a particular social group under that test for an immutable characteristic or characteristic that cannot be changed. The board had said that back in 1985, but nobody had the guts to really say it again, because they thought, oh, well, that means all women are going to be admitted, which of course it didn't. You just had to, the basis of the discrimination had to be one of these grounds, but religion, race, all of these were large categories, and the narrowing takes place when you think about persecution, when you think about what constitutes a well-founded fear, all of the other kinds of elements. But, you know, the advocacy community was, sometimes it was hard to get our colleagues to take international law seriously, or to take the importance of a law-like regime. And I will say that. So the people have said, oh, well, you know, it'll be, if we just make it narrow, we don't make it about, for domestic violence, we don't make women be the category, but women who are unable to leave a relationship. And eventually they actually got the board to adopt that standard, that women who are victims of domestic violence could receive asylum because they were unable to leave the relationship. They were women and unable to incoherent. You know, the UNHCR, the United Nations High Commission for Refugees, had contributed to it. I participated in a meeting that they had about defining what the particular social group ground meant, and they put either an immutable characteristic, gender could qualify as an immutable characteristic, or social perception of women. And we said, no, you don't understand. It's not going to be or, it's going to be and it's going to screw everything up. And indeed, that's exactly what happened.
I'm sorry, Debbie, we're running, you know,
Yeah,
we just
no, I'm so
but
sorry. What was I
anyway,
supposed to talk
Jeff
about?
Sessions tried to basically
Oh, yeah,
eliminate it altogether.
He tried to eliminate the say that no women who is a victim of no domestic violence, no case involving gangs, could get asylum. We kept arguing it can if you think about this the way Justice Alito thinks about this.
And that led to a case in the First Circuit, De Pena-Paniagua, if we can just
So
touch on that.
this was a case that Steve Schulman, Aiken Gump has been unbelievable in helping us
Yes.
whenever we needed it, and then some. So yeah, we argued a case. You were counsel for amicus, right? We were amicus, and we argued that the gender itself should define the particular social group. And the court actually agreed, right? Said, I don't know why you're coming up with this complicated thing. It's not right that they're rejecting it, but why don't you just say gender defines a particular social group? And they were like pages from our amicus brief that they just put into the decision. So that was a wonderful moment. And during the whole time when domestic violence cases were being trashed, and you know, by the board and by others, more and more judges were saying, immigration judges were saying, we have 1 minute left.
Yeah, and then the last thing I just want to touch on quickly is moving forward, climate change and the intersection of asylum law. And the clinic was part of a joint paper with some other groups called Shelter from the Storm that talked about that. And I don't know that we really have time to get into that now, but it just kind of shows how the clinic continues.
But yeah, it is an important, very, very important new issue. You know, the extent to which the Refugee Convention can be a part of a solution for people who are displaced by climate. And this is going to be, there's hundreds and hundreds of thousands, millions of people. That's what, like, was it? I can't remember what the number is in Central America in the next 10 years. So we're in a lot of trouble with this. We're in a lot of trouble. And yeah, it was great that refugee law had matured to a point where we could use it. There's now a very serious book out on the subject by an academic, Michael. Anyway.
But just, I'm sorry to cut you off, Debbie, but in conclusion, I know
conclusion.
there's going to be a lot of toast coming up later, but you know, as somebody who really cut my teeth learning from all the work of the clinic, from all of your writing, who for whom you served as a mentor, as a role model, to whom you showed that if one uses imagination and just never gives up and keeps trying to bring about change, that anything is possible. I can't imagine what asylum law would be like if it wasn't for you, Debbie, if it wasn't for the three of you, if it wasn't for all, the present leadership and all the students and others that have come through the clinic. And just from the bottom of our heart, I think this whole room wants to thank you. I don't know what else to say.
Thank you. What? Yeah. I know we don't have a lot of time, but I just want to thank all of you who are here. I want to especially thank everybody in the clinic, especially Phil and Sabby, who I really feel like have taken what our basic values, which are, client-centered, and are developing it at a much, continuing to develop it, and have won over our dean. Is he here? He's not here, right? Okay. I can say anything I want about him. But I've gotten more resources, and I think we do things at a lot of different levels, which I think has made this clinic different than others, because we do all of this stuff. But we've also done a lot of policy work, a lot of big conferences and speaker. It has those dimensions, and they've done an unbelievable job in organizing events and people to come in, and they're just fantastic lawyers, and everybody in the clinic is. I'm just very grateful to be associated with them, and have to thank. Oh God, I had a list and I'm going to forget them, and it's going to be really bad. So who am I forgetting? Well, everybody in this room practically has had a real contribution to this field, and
Lisa, should we say something? Lisa.
And oh my God, yes, Lisa. Lisa Dealey is here. Lisa made. There's a whole other story that could be told. We could have a whole other session on what happened to clinical legal education
That's
at
after
Harvard.
a few drinks.
Clinical education is now taken very serious, much more seriously than it was. We've got a whole cadre of clinical professors, but that all happened because of Lisa. Lisa and Elena Kagan. Elena Kagan actually started our clinic here at Harvard. Something about student satisfaction is the reason. So I guess they were worried about us. Lisa, and who else am I
And your
forgetting?
family.
My son and my husband. And my son's friend Arden. Somehow they've lived with me throughout all this. It hasn't been easy, for sure. And Jeff, oh my God, I don't know how many of you had the chance to work with Jeff, but he's a gem. He's a total mensch gem, and has really helped us through so much. So I'm just very grateful for the relationships I have with so many people here. My friends Don and Jenny for coming, and Steve Schulman, and anyway. I'll stop, but I do want to thank Martha Minow, also, who the reason we have a crimmigration clinic, which is what Phil is heading up now, is because of Martha. The reason we have a student group that has the stature that it does is because of Martha. So I'm going to stop. Thank you guys all.